huge thank you to, first of all, everybody who's joining us and taking important hour of their schedule, but particularly my wonderful speakers today. We've got a great combination, not just of talent and skills, but actually different people in different roles. So let me introduce Karolina Mojzesowicz, who is the Deputy Head of Data Protection Unit at DG Just, the European Commission, and has been behind the report on GDPR 6 years that the Commission has published. Elise Lassus, Project Officer at the EU Agency for Fundamental Rights, again, working on this really important report that FRA has done on the role of data protection authorities and how they have coped and managed under GDPR. And then, of course, Hielke Hijmans, who is Director of the Belgian Data Protection Authority in charge of its enforcement and a long-standing collaborator and with CIPL. And finally, myself, I'm Bojana Bellamy. I lead Center for Information Policy Leadership. This is an incredibly timely conversation to talk about the 6 years of GDPR. What have we learned? What has worked? What are some of the unintended consequences, and what are some of the perhaps unfulfilled challenges or promises, particularly as we are continuing for really a couple of reasons. One, we are continuing this huge digital transformation, and we are seeing transformative technologies and new technologies like AI, blockchain, neurotechnology. And the question is, how do we make sure that our fundamental privacy rules and regulation, GDPR, stays technology neutral and future-proof and manages to adapt to these technologies. Of course, we are seeing a huge regulatory tsunami as well on digital front in the EU in particular, with a number of other adjacent areas in data or technology regulation. And so the question is, how does GDPR work seamlessly with those other areas of digital regulation? And finally, it is time, it is 6 years old. It's time to think about, what can we do all better to make sure we indeed realize the important objectives of GDPR. I wanted to share with you very briefly, in way of our own comments, some of the findings from CIPL's own report that we did earlier this year in May 24. We based this report on our own research observations, but as well as survey and discussions with CIPL member companies, where we really tried to collect all this evidence. I'm really, first of all, very pleased to say that many of the findings of our report correspond to what the Commission has published, and we haven't talked to each other at all, and in fact reflect a lot, well, certainly on the area that FRA has been looking in respect to Data Protection Authority. So that is really encouraging to me, and it means that there is really consensus around some of these things, right? And maybe let's go into some of these details, and I will then ask all the other panelists to also share some of the highlights of their report, and then we will start the conversation and of course take your questions as well. First of all, very importantly, it has been successful and good 6 years. I mean, there is really clear sense of achievement. The GDPR has had positive impact on organizations, impact on individuals, and of course on regulators as well. And we've seen positive change on all of these three fronts. I always used to say this is really where it's all going to matter. In terms of organizations, we know that very well because we work with so many. There's no doubt there is a higher data privacy awareness and ownership of this topic in organizations. This has become a C-suite, a board level issue, obviously, for the reasons which are to do with risk and regulatory compliance. But very importantly, it's also shifting because data is becoming such an important asset, driving economic growth, driving companies' competitiveness, and also digital trust. So the way we handle data has got huge impact on all of this. And I think this is what boards and C-suite are starting to realize now. So we see this shift from very much focused on risk and defensive positions into actually doing privacy because it's good for the business. And I think that's something that needs to be absolutely further incentivized and further supported as well. Of course, we have seen the growth in organizational accountability, companies developing and implementing data privacy and compliance programs, and implementing these across the board, even across their global footprint, because it kind of makes sense as well. And that meant, of course, better data management, better data hygiene, companies knowing where data is, how they can use it also more effectively, managing the risks with third parties as well. When it comes to individuals, there's no doubt, much more awareness. People actually know what GDPR is these days. They're exercising their rights. They are realizing benefits from the increased transparency that we are seeing. And certainly data protection authorities, again, we've seen certainly stepping up to this new challenge in terms of their capabilities, in terms of their effectiveness as well. And we've seen some really interesting and smart guidance and thinking coming out from data protection authorities, in the areas of children's rights and protection. We've seen some interesting guidance on AI, some interesting, again, tools like sandboxes, CNIL, UK ICO, innovation hubs, working with data protection officers, working with SMEs. The technology capabilities are stronger. You've got now special AI units in number of DPA. So, again, really, really positive, and certainly better cooperation among the cohort of DPAs as well as with the other regulators. So lots of great progress. However, there are some challenges and areas of improvement. And let me just I'm not going to go through all of these, but just focus on some themes. I think we can kind of say, hand on heart, the ambition of GDPR was excellent, and the foundations of the construct were excellent, but it hasn't been quite realized for various reasons. And it doesn't really matter. It's not about any blame. It's about how do we make sure we realize the potential. Certainly from our perspective, CIPL wanted to see more focus on accountability and risk-based approach in the regulatory work. We wanted to see more considerations of risk-based approach in regulatory guidance, in enforcement. That hasn't quite happened, I think. More incentivization of accountability and really building on what companies have to do to actually deliver what is effective compliance. There is still lack of clarity on what harms and risks we are trying to identify, and there is no framework to measure that consistently in terms of likelihood and severity. And I think this is really going to be hugely important as we now extend our ambit or risk assessments to AI, children's protection, and looking at these other competing, like online safety. Lots of laws are requiring risk assessments. We are going to have to do more of these. One-stop shop, we can talk about that. It was a great ambition now. Things are getting better, but not quite realized, perhaps lack of harmonization. And I think certainly the potential of codes of conduct, certifications, even binding corporate rules to be seen as a certification or some kind of seal hasn't quite been realized. Then we have got a sort of second thematic point, which I think is important, where these are really substantive, I think, shortcomings. GDPR has not proven to be quite technology neutral. I think we are challenged to how to interpret principles and have seen rather different points of views, specifically on AI, blockchain, on research, for example, clinical research, and generally scientific research. Data transfers, that, from time to time, we have these sort of very seismic shocks. We've just had one with the Uber fine. The question of how GDPR will work with other digital regulation, how the inconsistencies, the overlaps will work, I think that's going to be also substantively very important. And then maybe finally, I think we've seen some conservative interpretation for data protection authorities around some key concepts like personal data, anonymization, even data flows, or legitimate interest, contractual necessity. So again, it's not structural, but it is actually how it has been implemented in practice. And then finally, I think when we look at DPAs, one of the things we noticed is that we think they are under pressure. They are really focusing so much on enforcement over engagement and transparency and consultation. It hasn't quite been the same as in the past, where there was much more of consultation and working together, which I think is hugely important in this new world of digital regulation and technologies. And secondly, really, we feel the DPAs have been overburdened by complaints, by breach notification, which has impeded them to do really what we think was more would be more necessary or more effective or perhaps more risk-based. I mean, there's more about all of this in our paper. Please have a look at this. And very briefly, again, when it comes to recommendations, we've kind of looked into what does CIPL think we should be focusing on, and you will not be surprised. In particular, we are calling on more realistic evolving guidance and interpretation with more transparency, ex-ante consultation, incentivization of best practices and accountability, a more risk-based approach, and outcomes-based approach to oversight, regulation, and enforcement. It's going to be really interesting to see how GDPR works with all the other areas of digital regulation. And I think, if you go to Brussels or at any conference, this is becoming such a big theme, and one that I think is going to be interesting for companies who will have to absolutely leverage their digital compliance and learn from GDPR to do the others, but also think how the two work together, but also for regulators who are going to have to cooperate with other regulators, but also evolve their own thinking. Data Protection Authority, Hielke, I'm looking at you here as to how GDPR now works with these other important objectives like online safety, like cyber protection, like AI innovation. And that's going to put more pressure, frankly, on everybody. But anyway, there is everything to look forward to and everything to work on. That's why these times are really very exciting. Maybe at the end, just last comment, because I can't ignore this. Many of you have probably seen that just yesterday or 2 days ago, we've seen the report, very well, much anticipated report of Draghi, who looked into the Mario Draghi, former president of the European Central Bank, who looked into the kind of overall question of European competitiveness. An incredibly thoughtful, I thought, and thorough report. It does talk about some of the things that we care about here and that you work on. I mean, he does say, that there is this kind of perhaps fear, but also concern that this overregulation, digital regulation, is going to make it very hard for companies in Europe to comply, particularly SMEs, and may impact their competitiveness ultimately. That some barriers to scaling up are also in the areas of regulation. I mean, GDPR has been mentioned again, and AI as well, not because they're bad, but again, how they need to be implemented in a smart way to actually enable innovation and enable competitiveness. And he kind of talks about these limitations of data storing and processing are creating high compliance costs and maybe hindering also Europe's ability to actually innovate using large data sets. And this is very, very interesting, right? And again, it's because we want to make this right that's why Draghi is calling these things. Final point is that it's not about legal compliance. This is really very much about geopolitics and overall competitiveness, industrial policy. So companies really need to think very, very hard how they consider this digital compliance and digital regulation themselves, just like the Commission has to do, and member states, and of course, the regulators. So those were my opening remarks and sharing with you some of the findings of CIPL's report. But I would like now to ask our panelists to, give us their take on the 6 years of GDPR. And maybe Karolina, why don't I ask you to present the Commission's findings? And particularly, I love the fact that the Commission was very much solution oriented and sort of, here's the action plan and where we're going to be working on to iron some of these hurdles and fulfill the potential. So we'd love to hear from you, and then we'll ask Elise and then Hielke.
Thank you very much, Bojana, for this very, complete introduction. Actually, I'm a little bit struggling to think about what can I add. Our report was what can I add? Is that our report was actually much more positive and the results, which were based on several sources, on the position and findings of the Council, on input from stakeholders, in particular through the GDPR multi-stakeholder group and through the call for public evidence, contribution from data protection authorities, contribution from fundamental rights agency. So a very broad group of sources confirmed actually, or allowed us to state, that the GDPR continues to deliver effectively both for individuals and for businesses. That this risk-based approach and technologically neutral approach provides for strong protection and is a priori suitable to find proportionate obligations for data controllers and processors. We did, however, find that there are certain actions or certain areas where improvement, certain actions which could be taken, and certain areas of improvement. And as such, we identified 4 groups of actions or areas of improvement, which focused on where the focus should be on robust enforcement of the GDPR. And here we were, of course, thinking very much about the proposal, the Commission proposal for procedural rules. We were very much focused, and here the link with the Draghi report, on achieving more consistent interpretation of this of the GDPR across the EU. We were deploring some fragmentation, not only through the sometimes not necessary legislation on the national level in the areas where it's allowed, and sometimes even in the areas where the member states do not have any margin of discretion to further specify the application of the GDPR on the national level, but also the fragmentation caused by diverging interpretation of the GDPR through the data protection authorities. And here we called very much on the EDPB to really foster more coherent interpretation and coherent enforcement of the GDPR. And we called also on the data protection authorities to abide by the this guidelines or a variety of documents which they adopt, where they are regrouped within the EDPB. And then another element of which we are very much aware of, the area of actions, and this is the area of coherent interpretation across different new legislative instruments. So not only no fragmentation and coherent interpretation of the GDPR as such, where we see this divergent interpretations by the DPAs, but also the coherent interpretation and enforcement of variety of legislative tools which are which build on each other or which complement each other. And here I think in particular about the new legislative, about the new acts, let me call it, be it the DSA, so Digital Services Act of Data, and then Data Governance Act or Data Act, and of course artificial intelligence, where even Data Digital Markets Act, where this acts to some extent build on notions provided for in the GDPR, and to some extent specify some GDPR notions or solutions in a specific areas. So we were, of course, always calling, and we do want to have more improvement also in the area of supporting of stakeholders' compliance effort. And here we think in particular about the SMEs. So I counted out 4 areas which we listed in the report, where we think further attention or further actions, again, I'm not sure it's the most correct word for it, but it's the areas where these actions need to be taken in order to achieve the necessary improvement.
Mm-hmm. It's really good to hear that, Karolina. In fact, I think yesterday I heard that maybe today or tomorrow we're actually going to see one of these first joint cross-regulatory guidance coming out in respect of DMA and GDPR, if I'm not mistaken, between Commission or EDPB. And I thought, well, that's exactly what's needed. As you know, CIPL has been working a lot on the overlap or intersection between various D acts, as we call them, and GDPR. So we think that guidance is really well needed. Am I right to say that there will be guidance on DMA in particular and GDPR? Is that what?
Yes. The Commission and the EDPB are embarking on the work on this joint guidelines. So this is the endeavor. We will see where we will get. But indeed, as also underlined in the report, this effective cooperation between national and EU enforcers, not only, and obviously because the EU is not enforcing the GDPR, but across variety of acts, is from our point of view very important in order to achieve the digital the aims of digital strategy of the EU.
Final question to you, just quickly. There's been some language in that report which sort of said, there might be some targeted review or slight small changes or tweakments of GDPR, perhaps, the age of children's consent, then the SMEs were mentioned, research was mentioned. Are we to expect any small targeted actions like that? And then how would that take place? Because opening this is a legislative, is there going to be a review of GDPR legislatively? I don't think so. But how do you make change then?
Oh, well, I don't think in the report we wanted to transmit the idea of, let me call it with this tag word of opening the GDPR and the review of GDPR. We think that, and actually all the stakeholders were pleading against that. There is, in the light of this really almost tsunami of the new legislative acts, the businesses, stakeholders were pleading for a stability, in particular of the act on which all the others, as far as processing of personal data is concerned, are embedded. So from our point of view, this clarifications or actions in the areas mentioned can be achieved through interpretation or a different interpretation. So far, we do not think about opening and of the GDPR, be it through targeted, be it through broader changes, because as you just said, indeed, it would be difficult to achieve the stability the stakeholders ask for if we start to open thinking even about very targeted changes, but then it can spread more.
Okay. I think this is also something that we at CIPL felt as well. There is a lot of as I said, the construct is there, the raw materials are there. It's about how we interpret that and how we work on that.
Yeah.
Okay, well let's move on and maybe ask Elise Lassus from FRA to just give us again some highlights, Elise, from the report that FRA has done at the request of the Commission on DPA sentiment as to how GDPR went, and particularly about DPA's effectiveness or some challenges and, of course, positives as well.
Thank you very much. So good afternoon, everybody. Thanks a lot for inviting us to say a few words about our report. It was published earlier in June this year. Yeah, so you're right. I wanted to say a few words about the background and the methodology so that, the audience can understand the scope of our report, but also its objective and limitations. So we did indeed launch this data collection at the request of the European Commission that wanted to have data that would be complementary to their own data collection. So to go a little bit beyond consulting the stakeholders, and they asked FRA to have face-to-face interviews with the data protection authorities so that we can discuss the challenges that they face, and we can get a practical understanding of these challenges, but also to collect promising practices, best practices. As you know, if you are familiar with FRA's report, you may know that we don't say best practices, we say promising practices. And above all in this report, because we didn't test them. So we are, bringing forward the voice of the DPAs when they are explaining what they've been trying and testing in order to, face and overcome the different challenges that they have when it's coming to the implementation of the GDPR. We looked at the question of independence. We looked at the supervisory powers and investigatory powers and advisory powers. And then we also looked in the fourth part to the question of cooperation at the EU level, so between DPAs, but also at the national level, the cooperation with other public bodies at the national level. So I think that what was quite interesting is that, of course, the number one issue that came was the question of resources. Yeah. And that's not a surprise. This has been highlighted already by different stakeholders, beginning by, of course, the EDPB in the past years. But what is interesting is that what we, I think, managed to evidence in this report is that the lack of resources has a multi-layered impact. It really impacts every aspect of the work, every, yes, not only what they have to do, but what they believe should be done in order to make sure that implementation is effective, which is not only the phase of the supervision and investigation that comes after a complaint or that comes after a violation, but in order to make sure that there is an effectiveness in the protection of this right, it should come before. Like there's a number of work that the DPA, thanks to the expertise and knowledge, could be doing. And this is highly prevented by the lack of resources. Another point on resources, and I think that this is quite interesting, yeah, is that it's a persistent trend. So we put our research also in parallel with other research that we've been doing in the past years. And what we've seen is that lack of resources is something we highlighted in 2010. And, it's 6 years of the GDPR, but at least from the first research where we looked into it, it's been 14 years. And this is something that DPAs were already highlighting as a very important issues. So a few words very quickly about some of our findings. I won't enter too much into details, and I can put the link of the report in the chat afterwards. First of all, when it comes to the discussion of the supervising powers, investigatory powers, what we've seen, and on these, we completely agree on what you were both saying, Bojan and Karolina, is that the majority of interviewees said globally, GDPR provides adequate tools. So we have a good roadmap, we have good tools, but when we implement this practically with concrete cases, we see that there are some cases where this could be complemented. So there was a few examples. It's not in all DPAs. In this, it was also expected, but we can see that there is two trends. There are, DPAs that have been established for a longer period, that have diversified their tools, and that didn't pinpoint that as being an issue, but smaller or younger DPAs did say that indeed they feel that they do not have all of the investigatory tools that they would need in order to effectively conduct investigations. Second point is, you mentioned it, high number of complaints. This is an avalanche. And what we've seen is that DPAs are still testing ways, including, technical ways, in order to reply to this. But interestingly, we didn't find one interviewee saying, oh, we found a solution, use this amazing software and you will be able to deal with this. Now, all of them were saying, well, we're testing, we tried this, it worked well, but we still need a bit, more time. So addressing the high number of complaints is still in the testing phase. And third point is that this high workload is preventing DPAs from conducting ex officio investigations. And this is something that, a number of them said, well, we really would like to do more on this. We really believe that if you want to have effective implementation of GDPR principles, we need to be able to do this. So here again, we're not talking about some, shortcomings in the legal framework that's not linked to the GDPR. The GDPR is providing the tools, but it's a question of resources, staff and time. And this is linking me to a second point I'd like to make regarding our findings, which is when we looked into the advisory, not power, but the advisory role of the DPA. Really large majority, so I think that almost all of them mentioned it at some point or another. What they're saying is that providing advice is of utmost importance. And yet, there is a de facto tension between these two roles because oversight and supervision is absorbing the most time, the most staffing, and the most technology. And we really, so that, whatever the level of the expertise of the person we were talking to, because we've been talking with chairs of, presidents of DPAs, with legal experts and with international cooperation experts, or cooperation experts in general, and all of them were mentioning this. We want to do more, but we just don't have the time. The notice that this is having an impact on, or better said, the lack of resources, the lack of time, the lack of staff is having an impact on the ability to provide advice to every layer of the society. And here I'm getting back to the multi-layered impact. So it's having an impact to provide advice on data controllers, businesses, public bodies, researchers, on data subjects, so that they're informed on their rights, public administration, when they have to provide opinions. Some of them were saying, well, we would like to provide more opinions because, or to have more time to provide detailed opinions. We just don't have the time. And but we will be talking about it, especially when it comes to new technologies. Yeah, I wanted to say a few words about recommendations, but I see the time, and I don't want to take too much time. Just one last thing about the this point on providing advice, what I think was really interesting is that we at FRA, and we know also other entities who've been conducting surveys about awareness of data protection. And of course, post GDPR, there was a huge rise. But what these experts told us is that there is a huge difference between being aware and actually understanding the data protection principles. And this is where providing good advice is key, actually, and has a snowball effect on the effectiveness of the implementation. I'm stopping there because I spoke too much already.
No, not at all. I mean, I can listen to you the whole day. And in fact, you know, it is so complementary to the work we've been doing a lot. We've been doing a lot of work on smart regulation and effective regulatory oversight, which I know Hielke will certainly mention as well. And it's really interesting. I mean, Richard Thomas talks about selective to be effective, and how does a regulator in a strategic, very risk-based approach puts its priorities right. That's really important for regulators to do, as opposed to be driven by where the complaints are coming from. I wonder whether, when I talk about incentivizing accountability and putting more onus on accountability, could we not have a solution where, in fact, it is up to the organizations to be accountable and have a complaint handling procedure as a first instance, and only then things go to DPAs? I mean, I don't think that would be against GDPR. I mean, these are little tweakments that, in fact, many organizations who are on this call are doing that. But I think, you know, that would help, certainly, DPAs. And then this other point about needing for preemptive ex-ante advice and engagement. I mean, that's, again, what we keep hearing all the time. Better engagement, better conversations, more transparency is going to avoid problems downstream. And in fact, it's easier to talk and find the solution than it is to litigate and enforce. But you know, these are things, of course, regulators have to do both. So I think we have some solutions for this, but it requires a little bit of a shift. But thank you for saying this. Hielke, I know you are patiently waiting. Could you please give us your comments on what you've heard? And I know you will have views on what FRA has found vis-a-vis DPAs, but also the whole point about that Karolina mentioned and our report mentioned, DPAs having this conservative interpretation from time to time, and also not seeing eye to eye between each other.
Thank you very much, Bojana. Thank you, everyone. I'm really happy that we have this occasion. I'm also really happy that you wrote this report, because it's very good also for us DPAs, or for us as individuals, to now and then have a mirror. Of course, you challenged me enormously by starting about conservative interpretation. Well, that's something we don't want to be identified with, but let me say a few things on this. Conservative, yes, but we are also, the point also mentioned by Karolina, we as DPAs are there also to ensure stability, also to ensure that there is a sort of line, a sort of stability on how the GDPR should be applied. And our role is, I think, less to encourage the opening up of the GDPR, but more to ensure as DPAs that we are actually doing our work and actually capable to do this. Resources, Elise talked a lot about it. I will not hide behind it, because I think that's not fair, but I'm very happy that someone else does it and gives us so much view on this. A few remarks from myself. When we talk about conservative interpretation, a lot has been said on legitimate interest. I think if I see what we do at the moment, the Court of Justice helped us a lot by giving this 3 steps approach. In this 3 steps approach, we are capable to interpret, in my view at least, legitimate interest in a harmonized and in a smart way. Of course, not everyone is doing the same, but that's another problem. You said at a certain moment, well, we still don't know what harm and risk is. I think in the way our society is changing, we will never know exactly what harm and risk is actually, but we should have some ideas, and I think there's sufficient guidance on this, or maybe not sufficient, and then we should work on it further also in the framework of the EDPB. Accountability, risk-based approach did not deliver, I read in the report. Well, I think a lot has been done already, and a lot should be done in a common effort between mainly with controllers, with organizations, and also with the help or in consultation with the DPAs. I come back to that. Brings me to enforcement. As CIPL says, for years engagement is more important than enforcement. You also know that I happily disagree to this to a certain extent, because in the end of the day, our role is to enforce. Enforcement means with strong enforcement, engagement comes, or you can see it the other way, but I think that that's an important element to keep in mind, that there must be and enforcement is not only just a stick, it can also be to guide. You can also, when investigating cases, we find out a lot about what actually is happening on the field and how things could be better. But part of it is litigation. Litigation costs energy and time. And if I see at my own work, I think I'm half the time busy with procedural law and not with data protection. I don't complain because I like it, but this is also part of it. Complaints, setting our agenda. Yes, and I think there we have a big problem. We're all looking for solutions. We put strategies in place. We try to diminish the role of complaints. On the other hand, we all realize very well that the reason why we exist is also to help individuals when they have real problems. But it's something we are all struggling with. And what you said is, for instance, that companies should put in place internal systems to handle complaints as a first start. Well, that's a way we definitely think we should be doing. On DPA's further engagement, yes. How, that's another story. I think it's important in any case that are not acting as an ivory tower. There's different ways, consultation, but also, for instance, these round tables or even structured round tables with external people to have a mirror to know what we're doing and if our strategy, our priorities are the right ones. A point on cooperation. The one-stop shop did also not deliver. I read somewhere in your report. Yeah, you can say a lot about it. I think about the one-stop shop, it turned out differently than we thought in the beginning, because we never thought that all companies, all big tech companies, would all go to one member state, and that would be the effect. I think, contrary to what you say, it is good for harmonization, for European law, that there are relevant and recent objections made against positions of the LSA, the lead supervisory authority. I don't know if how specialized all the attendance is. In any case, it is good, I think, that on major points the EDPB, or at least the group of European Data Protection Authorities, take a point in enforcement cases. So I'm not at all against the fact that we now have more and more cases which are dealt with on the European level. I also think that you should always think about one-stop shop mechanism. It was never meant as a mechanism where there was really a lead authority leading everything, and then some concerned authorities somewhere far away. No, it was meant as a real cooperation process. That didn't deliver completely because we cooperated mainly in the end phase, and I think proposal mentioned by Karolina is one of the reasons to solve that particular problem. I will not go too long, but the next point, I think, data protection in isolation, that is an issue more and more with all the new instruments coming into place. I think as DPAs, we should do part of that work and should work in a much more structured manner together with other authorities, which is not easy because it's already it's not because of resource, but it's already quite a job we have. And if you have all the time influence from others, it makes it more complicated. But I think it should be on the top of our agenda. And we know it. We see it in practical case. We saw our not by many not liked opinion on pay or consent, which I think has a lot of merits. But one of the things, if you look at it more in detail, you see that in order to protect individuals, you also should look at certain competition elements. You should look consent also has to do with power, for instance, from certain companies. Or so you must. It is not in isolation, and we should, and it's part of it, of the whole development to do that less and less. And I think that should be one of our top agenda points for the next years. Finally, on the GDPR in a broader worldwide context, I think preparing it, I look back at a small video with Anu Bradford, who has had this her book on 3 digital empires, where she explains a lot of things. But one of the things, it's a standard setting role where the European Union can play a big role, and I think that's a role. It is important for different reasons, but also that high standards also to protect individuals, and mainly to protect individuals in a much more complex world, is necessary to save our liberal democracy. So I really feel that what the EU is doing in standard setting is very important. I'm not going into this out of my comfort zone, talking about whether or not we should have European tech companies more, but this is what I would like to say.
Hielke, thank you so much. This is incredibly thoughtful. As I'm listening to you, I'm kind of remembering what Elise said, more work on everything. And the question is, how do DPAs find time to do all of these and improve and spend time on the areas that actually matter and are more strategic? And I just think you guys have got incredibly important role to play as a key digital regulator, and I think it's a really tough one. And so any criticism comes with that caveat, but also it's the fact that you can't do it all, and you have to be incredibly focused on what needs to be done. So look, I'm looking now at the time. We've got about 11 minutes. I want to make sure that please, I want to make sure that we invite some questions from the audience or comments in the chat. Please start writing that. But in the meantime, while you are thinking, I do have one question that I'd love to discuss with all of us, because this is the question that actually is being debated a lot these days, and that is actually how do GDPR principles and requirements sit and regulate AI technologies. In particular, how do we deal with tensions and difficulties in interpretation around legal basis for processing, training data, first-party, third-party data, rights of individuals? Are they really? How do we exercise them in respect of AI? Even purpose limitation, potentially sensitive data. Well, that was a legal lacuna, but AI Act has plugged that helpfully for high risk, right? So there is now a legal basis to process sensitive data to avoid bias and discrimination. But look, there are a number of consultations out there by DPAs, some very thoughtful guidance, but I think there is also divergence. Hielke, you talked about that. People don't see this the same way. And it's really important that we enable responsible AI in Europe. And so, GDPR can't be a stopper. It has to be an enabler. So how do we interpret these principles in a way that enables this, but provides for protections? Karolina, Hielke, Elise, of course, if you want to comment, what do you think? And we know that there is now guidance being prepared by DPB, right? That is coming as a result of the Irish DPC, Data Protection Commissioner, sending a matter to the EDPB for consideration sort of early on in the process on the use of training data. But can we talk a little bit about that? And what do you think? How do we really interpret these principles in this new way? Do we not? Or do we say can't be done?
Well, I think I will just, if I may, Bojana, I will just repeat what our understanding was always. It's first of all, GDPR applies, independent of AI Act, and GDPR applies to all processing of personal data, independent of other instruments. A part of that where you have maybe some specification, and here I think, for example, about adds up in Data Act in Article 4, which changes a little bit the right of access, develops it further, or develops then the portability and in Article 5 in the specific area of interconnected devices. But I think the success of the GDPR lies in the fact that, although you were saying the opposite, it's technologically neutral, and it can be and depends very much on the interpretation, and the interpretation should be given in the light of the also recitals of the GDPR, and here I think in particular recital 4, namely interpretation which expresses the balance between different fundamental rights, also right to provide business, freedom of expression, and so on. This was always the position of the Commission, so I don't think it surprises anybody what I say now. And I think I'll stop there. Indeed, there concerning a lot of questions on AI. I think there will be, well, EDPB will pronounce itself while answering to this request for an opinion. There, again, it has opinions under Article 64 have the advantage of being that they will be delivered fairly quickly, but the disadvantage is that they are not subject to public consultation. Right, and this is also something the Commission was very much underlying and saying that GDPR provides for different tools of cooperation between the authorities in the part on consistency, or in this chapter on consistency. Well, they should be deployed in a way which is the most suitable to the subject addressed, and I think that well, they are. There are subjects which can be very efficiently and well answered through an opinion, but there are subjects which will which require a broad consultation of the stakeholders, and then a different tool should be contemplated. I think I'll stop there.
Thank you, Karolina. Hielke, by the way, there is a question also when you answer that. There's a question there in the chat. Do you think, and everybody's welcome to answer that DPAs would be an appropriate regulator and enforcer of the EU AI Act? Of course, they're going to apply the AI, the GDPR to AI, and that's their role. The question is EU AI Act. But how do we solve? Please give us your point of view on solving some of these interpretation.
I fully agree with Karolina when she says that some issues we have to deal with are so fundamental at the moment in this change of time that we shouldn't do it, cannot do it in this quick procedure of Article 64, paragraph 2 for the specialist, that meaning with making an opinion in a very strict time frame, not allowing real consultation. I think some decisions are too fundamental, also cover too many other aspects of society where it goes beyond what we do as privacy authorities. So we should also definitely have the time to talk with other types of authorities, other stakeholders in the private sector, and academics, etc. So we're doing things at the moment which are very fundamental. One of them is the question which lies on everyone's heart, is the relation between legitimate interest and training. The training of data. I will not answer that because I think there's exactly a point where we should, my point of view is not interesting. I think this is so wide and so important. The second point, and that's what the question is in the chat was about, should the DPAs play a role, or what role should they play in the enforcement of the AI Act? I think that there's so much interaction, overlap between the AI Act and the GDPR, especially when it concerns high risk data, the famous Annex 3 of the AI Act. I think there should be a key role for the data protection authorities. Are they all ready for it? No. But so that we need also to, and that's what we're doing on a national level at the moment. And I think we should be, that's what we're doing at the national level. We should find how we can organize our way in a manner that we are ready for this. And that's, I think, also very high on our agenda. And on a European level, the EDPB gave a point of view what the role of the DPA should be in the AI Act, which is a role, a very key role. And I think that's something I wish here in public certainly to subscribe to.
And of course, some DPAs will be also de facto and de jure legally the enforcers of the EU AI Act, but probably not all, but they will, exactly.
There's a big problem, I think, between that all member states are doing that in a completely different way. This interaction or that this division or partition of responsibilities, and I think that's something which is not ideal.
Maybe I'm looking. Any other questions? Please send them quickly. We've got 3 minutes left. Karolina, you said that this is actually an important, and Hielke mentioned that it's a really fundamental point of interpreting GDPR principles for AI. And yet we have left this to a group of data protection authorities. With due respect, I mean, they're good, they're clever, they're smart, but are they the ones to interpret the law, to set the really what the law should be? Or is it the court, or should it be the commission as well? Should this not be a case for joint opinion or interpretation, formal interpretation, by the commission as well, in cooperation with DPAs, for example, just like you're doing on DMA and GDPR?
Well, we think that obviously, this is always the courts, the European courts, the Court of Justice, which will give the ultimate interpretation of the EU law, right? So this goes without saying. Therefore, we support big enforcement, a lot of enforcement, subject to full revision by the courts, because this gives long-term clarity and really the definitive meaning to a notion. In the European law system, it's the Court of Justice who is the institution provided for in the treaties.
But that will take a few years, right? Sorry to just interrupt. It's going to take so long time, and we need solutions.
Sometimes yes, sometimes no. In preliminary rulings, it can go fairly quickly, and then we see, although preliminary rulings give also then sometimes scope for interpretation. But therefore, we also we think that maybe there should be a scope for quicker decisions by the Court of First Instance in some areas, instead of dragging out this final say and final interpretation much longer. So then indeed concerning, and then I would be very, institutional, who is responsible for what in the area of competition law. The court, this is also very clearly provided what is the competence of the commission, and the commission is the policy maker and the enforcer of Article 100, 102, be it with data protection aspects, being without data protection aspects. And here I think there is also not a big surprise, but of course, and here I will fall back again on the judgment, as in the Bundeskartellamt meta judgment. The court underlined the cooperation between enforcers is very important, and this is also what we underlined in the report. Cooperation, we generally, from the Commission, you will hear, we want legal certainty, we want quick resolutions of issues, cooperation as we engage now in the cooperation with the DPB concerning the guidelines on the DMA. This is something that we are supporting, maybe also in other areas.
Good. Okay. Well, look, I mean, it is exactly the time is up, as they say. This was really fascinating conversation. Thank you so much for being fast in your thinking and in your reactions, and also, quite solution oriented. And it's always important to realize what the shortcomings are, where we need to focus, and that there is willingness and want to actually try to do better everywhere and look for the next steps. And that's what really we are looking for. So we look forward to working with all of you, of course, in supporting that project, particularly on the interaction of GDPR with other regulations, but also, how GDPR has to be interpreted in a novel way in order to stay relevant and to remain truly technology neutral as it was meant. So thank you for that. Fantastic insights. I hope everybody enjoyed. And then we might have part 2 in a few months' time, see how we're going all with the actions. Thank you very much. Have a very good day, everybody.